Gujarat grants parole to prisoners as Diwali gift. What it means? An additional public prosecutor practicing at the Gujarat High Court says that the government often takes a compassionate view on applications for parole during festivals of Diwali, Raksha Bandhan, etc., and the latest announcement is not out of the ordinary. The Gujarat government announced Tuesday that it has decided to grant 15-day parole to prisoners about above 60 years of age and women prisoners except those booked in serious offences as a Diwali gift. As many as 181 prisoners from jails across the state are said to benefit from the decision. What is parole? Furlough and parole envisage a short-term release from custody both aimed as reformative steps towards prisoners. While parole is granted to meet a specific exigency and cannot be claimed as a matter of right, furlough may be granted without any specific reason after a convict spends a stipulated number of years and is a matter of right although cannot be claimed as an absolute legal right. Both provisions are subject to circumstances of the prisoners such as jail behavior, gravity of offences, sentence period, and public interest. In 1992, Gujarat had issued a circular notifying non-grant of parole to NDPS convicts. For Gujarat, both the provisions of furlough and parole are governed by the Prisoners' Bombay Furlough and Parole Rules 1959. Is parole as Diwali gift as extraordinary move? An additional public prosecutor practicing at the Gujarat High Court says that the state government often takes a compassionate view on applications for parole during festivals of Diwali, Raksha Bandhan, and the latest announcement is not out of the ordinary. Given the legislative politicians do not have direct power, announcement only indicates that prisoners will have to make applications to all authorities concerned, which in turn will be considered with leniency and expeditiously. The application will, however, be subject to scrutiny and the prisoner's conduct and gravity of their offense. Who can opt for parole and how? The provision of parole is available to convicts found guilty by a court, trial court, or at the least, even if a conviction may be under appeal at a higher court. And such a prisoner or the prisoner's relative legal aid may submit an application to the prison superintendent, who in turn forwards the application to the competent authority, often under the jurisdiction of district magistrate concerned and comprising prison and police authorities to sanction release. After due verification of reasons and prisoner's conduct by the competent authority, an order for grant of release on parole will be issued. In case of rejection of the said application, a convict may approach the Gujarat High Court. The prison rule states that the parole period may not be granted for more than 30 days, and the competent authority may exercise its discretion in case of serious illness or death of nearest relatives such as mother, father, sister, brother, children, spouse of the prisoner, or in case of natural calamity. Parole or extension of parole cannot be granted minus a report of the police authority. Apart from the remedy to approach a high court for parole in case of a rejected application, a prison can also approach the high court directly in case of an extraordinary emergency. However, the announcement made by Chief Minister Bhupendra Patel excludes prisoners whose appeal are pending before the high court. NRI prisoners, foreign prisoners, those associated with terrorist activities and antisocial activities. What has been the parole precedent in the recent past? Specific to Gujarat, COVID-19 pandemic and cyclone Taukte were some recent circumstances under which the courts have exercised discretion in favor of prisoners for grant of parole. During the pandemic, in a bid to decongest prisons, the Supreme Court in March 2020 has directed states and union territories to constitute high-powered committee which in turn may determine the category of prisoners who should be released depending on the nature of offense, the number of years to which he or she has been sentenced, the severity of offenses which he or she is charged with, and the stage of trial or any other relevant factors which the committee thinks appropriate. In an affidavit filed by Deputy Inspector General of Police Gujarat in 2020, it was submitted that as of March 28, 2020, against a total capacity of 13,724 jail inmates across all jails in the state, occupancy was at 14,991 inmates, and following high-powered committee consideration of relief in light of pandemic and overcrowding in jails, it was decided to release 2,200 jail inmates either on temporary bail or parole or furlough. By July 2020, a total of 2,813 inmates were released, including 1,107 who were granted parole by high-powered committee. Thank you.